Hello, my name is Dave Zapponi. I'm the CEO of ECHO, otherwise known as the Educational Council of Homeowners. Thank you for participating in this live stream event, Board Ethics and Decorum, presented by Sandra Gottlieb of the law firm Swedelson Gottlieb. We are happy to have you here. ECHO is a statewide nonprofit association created to support HOA board members and engaged homeowners. Our mission is to foster better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. When hovering over the bottom of the screen, there are a few features that are available during the webinar. Please use the chat feature for any technical issues you may have. The chat feature can also be used to interact with other attendees and ECHO staff. If you have questions for the speaker, please use the Q&A feature found on the bottom bar. Questions will be answered during the Q&A session at the end of the presentation and some during the presentation. Due to the number of participants, we may not be able to answer all the questions during the scheduled Q&A session. In today's session presentation, we have more than 370 people registered, so it's a very large event. To help us select the most relevant questions of this audience, please use the thumbs up icon found in the Q&A feature window. Simply click to vote on the questions you'd like to be answered first. Please keep your questions general in nature. Questions about specific situations in your community are likely better answered one-on-one. Also, please be courteous and respectful of webinar participants, including the speakers, sponsors, and at all times. Any participant may be removed, blocked, or edited at the discretion of ECHO at any time and for any reason. Participants are solely responsible for their comments. Except for sponsors, this program is not a marketing forum for professional service providers. The event is copyrighted by ECHO. We do not give permission to others to record the meeting in whole or in part. The program will be recorded. A copy of the recording, along with presentation slides, will be emailed to registered participants within 7 days. Okay, so I'm going to say that again. You will get a copy of the slides within 7 days of the program. Please join me in thanking our premier sponsor for today, Kevin Boland Insurance Agency. We also thank our Q&A sponsors, All Bay Construction Solutions, Inc., and CID Consortium, Inc. Further, let's thank our registration sponsors, Restoration Management Company and TARC Construction. We will now hear a brief message from the Kevin Boland Insurance Agency. Connor?
Hi, everyone. My name is Kevin Boland, and I am proud to be a sponsor of our ECHO educational event today. You know, about 5 years ago, I started to sell and manage insurance for homeowner associations, and I really wanted to accelerate my learning curve. So I decided to join ECHO, and sure enough, within about 2 weeks, I found myself listening to CPAs and attorneys and experienced HOA managers share their expertise, and my learning curve, took off. So I'm really happy today to be able to give back as a sponsor. All right, so my insurance agency is located in the San Francisco Bay Area. My office is in downtown Novato, and we specialize in managing insurance for planned unit developments and condominium associations. So if you would ever like professional insurance advice, please don't hesitate to give me a call.
Thank you once again, Kevin, for your presentation, and thank you for supporting ECHO. I'd like to also thank the other sponsors for their continued support. Finally, our disclaimer. None of what is said during the seminar shall be construed as specific legal advice from the speakers, the sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney. So moving on with the program. Our webinar today is Board Ethics and Decorum, presented by HOA Community Attorney Sandra Gottlieb. Sandra is one of California's leading community association attorneys and a founding partner of Swedelson Gottlieb, which limits its practice to the representation of California homeowner associations, including condominiums, planned developments, and cooperatives. Sandra's extensive negotiating skills acquired and honed throughout the years throughout years of practice has given her the ability to work with volunteer board members, association managing agents, and opposing counsel to achieve intended results and to provide expert legal representation on association operational issues. However, Sandra is not limited to being an HOA legal star. Because of her experience, she also helps associations on many other matters and issues that impact California homeowners associations. We are very pleased to have one of California's leading HOA attorneys here today to discuss board ethics and decorum. Sandra?
Thank you, Dave. So nice of you. I appreciate being here, and I appreciate all the people that took time out of your day to be here as well. And we are going to try and get to as many questions as we can. Ethics is a tough class to teach. It's what I call the eye-rolling class, because it's not like contracts where you're going to leave with 4 things. It's sort of esoteric. But what we try to do is give you this framework in our outline so you can take matters back to your board and at least second guess or triple guess yourself, is this action right for the association? So in essence, business ethics is knowing what behavior and conduct is actually right or wrong in that professional context and what we can actually do in that context. What we do is we have principles that are established in our environment. And even though you live, presumably, in your condo or you have an ownership interest in a residential condominium, it's a business. These are corporations. And you as board members have to conduct yourself as corporate members. And therefore you're bound by the terms of not only your governing documents, but your CC&Rs, the Corporations Code, and of course, the Davis-Sterling Act. All of those things together will form the basis of the behavior that will give us our business ethics, sprinkle in moral behavior and responsible management. And today that will allow us to come up with a plan for your association. Connor, next slide. So what is ethics and what is proper decorum? How we do what we do. I look at this as a moral compass to determine what is right and what is wrong, and to make sure we make the decision on what is right. Ethical dilemmas are not clear-cut. In fact, there are often no right or wrong answers, which puts us in gray a lot of time. How you deal with an ethical issue really says a lot about you as a board member providing your service to your association. Because it's not black and white, we have to really work with the facts that we have in dealing with our ethical issues. Some of the times the issues are not the issues themselves. It's the perception those acts create for both you and for your association. We know all of our homeowners. Not only is the board of directors going to be protected for its action, but so is the homeowners association that you are representing. Because a breach of ethical duties by the board can actually expose the association to both legal and therefore financial harm. So when I talk about a moral compass, it's really just trying to get ourselves set up to see, is this the right decision for the association, or is this not the right decision, and how we're going to get there? So we have to look at professional duties and standards, and we have to make sure that we take a little bit of your personal life and those experiences, if you're an employer, those experiences, and try and come up with that ethical standard for what really is right or wrong. Our perceptions, however accurate or inaccurate they may be, can really result in a lot of negative activity in our association and by our homeowners. And what we want to do is try and come up with something that is completely defensible. Connor? So asking the right question is to ensure the ethical behavior is probably the most important part. And it's the one that I try and hone in on all the time. So I read a book a long time ago, The Power of Ethical Management. It was written by Kenneth Blanchard and Norman Vincent. and Norman Vincent Peale. And in that book, they ask 3 questions of a person when they're trying to make an ethical decision for which they have responsibility. And it really applies to what you do as board members. Is it legal? That's the first question. Is it legal? So how will we determine if it's legal? Well, we know we're stuck with the Davis-Sterling Act. Did I say that out loud? The Corporations Code, but your association's governing documents are also give you the inroads as to whether or not this is legal, because as it relates to your association, we want to see if it's actually enforceable. And then there's case law. Is there case law that is controlling on a particular issue? So those are the things that we want to look at. And this is going to form the basics for your ethical behavior as a board member. The next question is it balanced? Is it fair to all parties concerned? Does it really come down hard on one particular party who may be painted with somebody else's paintbrush, meaning they didn't really harm the association? Maybe they didn't really know that there was such a restriction and they came to you with a mea culpa. It does mean that they are still responsible for their actions, but if it's balanced, it doesn't mean they have to go down for their inadvertent action. And you have some latitude when you're weighing the ethical behavior that you're going to exhibit in trying to determine whether or not you have to deal with them in a disciplinary matter, or can you just say to them, you know what? We want to make sure that we're fair here, that this is a balanced decision. This is something that you can't do. You are obligated to understand what your governing documents say. And we want to also look at what's short-term and what's long-term. You're going to hear me say that a couple of times today. Your responsibility is for the long-term. And it's I call it the 3 Musketeers approach. And that's one for all and all for one, because we are making decisions that are going to affect this community years from now, such as your contributions to reserve study and the plans to actually make reserve repairs. And so it is important to understand that we're talking about not just today, but the future as well. The third thing that we have to ask is it right? Are you proud you made the decision? How is it going to look on the front of the newspaper, your regional newspaper? If you're young enough to have parents that are alive, what would your mother say? I always use that as a really good standard for myself. And then the final one is, how will this look 5 years from now? Is it going to stand up in this corporation to be a good, balanced decision? Is it legal? Is it balanced? And is it right? So Connor, if you can take me to the next slide, we're going to talk about conflicts of interest. So we do have a statute in the Davis-Sterling Act that defines 9 conflicts of interest for board members. When that statute was drafted, I called it the duh statute. I'm now not so polite about what I think about that statute. It is the obvious. I wish the statute dealt with the unobvious, right? Don't make self-serving decisions. That should be obvious. But conflicts of interest can arise when a board member takes action that personally benefits him or her in some way. Perfect example would be you own, or your brother-in-law or sister-in-law owns a dry cleaning company, and you live in a high-rise and your valets are all wear uniforms. And you decide that you're going to throw in a proposal from your brother or sister-in-law, and you can do that actually. But there are 2 types of conflicts of interest: apparent and actual. So in this situation, that would be an actual conflict of interest. If you didn't disclose that that vendor is actually related to you, and that directly or indirectly you would benefit by that relationship, you have created a conflict of interest for the association that exposes it to liability. You yourself are exposed to liability as well. Board members cannot engage vendors or take actions that are intended to be for their own behalf, which is why in my scenario, that is on your own behalf. If you think that is the best vendor out there, you can bring that to the board of directors. You can keep yourself out of any discussion or any part of the bidding process. And you can say to the board of directors, I don't want to be involved in this. I believe that this is a vendor that we should discuss. And then the board can make that decision as to whether or not it's such a great idea that they're going to do it. My philosophy, however, is the reality is there's enough vendors out there, And when you bring something like that close to home, the board and the particular board member in play is really always going to be suspect, whether or not that action or decision is actually adverse to the association. When a director is faced with an actual or a potential conflict of interest, make that disclosure and make it early on. Do not participate in any deliberation or voting, like literally get out of the room or leave the Zoom so that no one could ever tie you to an influence of that decision. And then ensure that the decision is actually fair and reasonable and in the association's best interest. I'll move on to the next slide, Connor. All right. So what would this look like to others if they knew that you actually made this decision? We also often say that ethics is what you do when no one else is looking. If you make that right decision and no one could know how you did it, you are that ethical person that I want on my boards of directors. You're thinking it through. You're not thinking about just yourself or the effect of this, and you're making the right decision for your association. When you come up with ethical behavior and ethical standards, it's really walking the walk as well as talking the talk. If you say to your staff, your general manager, if you have an on-site, or to the association employees, or to your vendor employees, you want honesty and you want transparency. Make sure that when you're dealing with those same people, that you are dealing with them in an honest and transparent way. Nothing is worse for a manager when they find out that a board is going into executive session. They didn't only not arrange that meeting, they didn't know about it. They couldn't advise the board on it. They couldn't help the board prepare for it. So make sure if you're going to put together that ethical and proper decorum, that you make sure that you are doing that all the way down in your community and that you're treating both your staff members and your homeowners by walking the walk in a really positive way. So I don't want to be held, for anybody to think that I'm being negative here, but I think board members should be held accountable. The reason I think you should be held accountable is there is a statute that says because you're volunteers, you are protected for your actions, and I want you to be protected. But in order to obtain that protection, I want to make sure that you do the right thing so that your peers, your other homeowners in your association can understand the basis for why you're making certain decisions. Then we have the documentation for the historical records that that was the right decision for your association. Ethics are internal. It helps so you can sleep at night. I always like that, but they're external as well. It's so that I and other homeowners association attorneys can actually defend our association clients and board members if they're sued on an action. This is why I always say document, document, and then document again. Be careful how you say something, speak with your managing agents and speak with your attorney to make sure that the wording of that documentation will protect the association. I am always looking for you to come out as scholars on the business judgment rule, because when you secure compliance with the business judgment rule, I am able to say you acted in good faith, and that implies an ethical act. Next slide, Connor. Thank you. So we have established standards of conduct and codes of behavior, and then we have how we investigate and we address misconduct. We shouldn't just desire truth and honesty, we must demand it. So I know when we are in your position as a board member, these people are your neighbors that you live with, and that it's always hard to say, hey, you're doing this wrong and you have to do this better. But I actually think that that's your job, because your job is to protect the corporate interest. And if people are doing things wrong and exposing the association to liability, you have to take that truth and honesty and you have to say it so that you know that the association is going to be protected. We all know if that one person gets away with an indiscretion at an association, others are surely going to follow. There has to be penalties for violations of that ethical behavior. We have to make sure those penalties are consistent with your own association finding policy, the authority in the association's bylaws, the procedures in the CC&Rs, and of course, consistent with notices for disciplinary hearings as we would find them in the Davis-Sterling Act. The success of business ethics is ultimately measured by how well it's ingrained in your corporate culture. So when your board says that no one can do such and such because that exposes the association to liability, let's say walking on the association's roof, that's off limits. That's where equipment is. Our particular building doesn't have guardrails. No one can do it. That culture, that decision has to be conveyed to everybody in your association. So your employees know if they say to somebody, no, stay away from that door, you are going to back them up, that you're going to give them that sprinkling of your ethics to protect them while they are trying to protect the association by enforcing your mandates. And create reporting procedures so everybody knows what to expect. I'm a real fan of not having to call everybody in for violations all the time. What I'm also a fan of is telling homeowners when they're going to be called in, what is inappropriate behavior. Unhappy days for Sandra is when I have board members that are doing the very thing that they are calling a homeowner in for a violation for. Please don't put yourself in that position. The liability is too great, and I don't know how that's not one of the most embarrassing moments, but I see it, and I see it frequently. I want those business ethics to make sure that they are impenetrable and that they are completely defensible at all time. If one board member is found to be crossing the line, no secret conversations. Everybody on that board needs to be told. One, because it's the right thing to do and it's a display of ethical behavior, but you might as well do it anyway, because that knowledge is imputed to all of you. If one of you knows, all of you know. That's one of the reasons that I say to my boards, stay off of Nextdoor and other social media. Because if you go on and you see something that is damaging, such as somebody is harassing another owner or a employee of the association, and you were on, and it can be tracked that you were on, and you saw that, and you didn't bring that information back to your board, I promise you, when the association and its board of directors are sued for those behaviors, that will wind up in the evidence pile. So when we know about it, we have to convey it to everyone. Then we have to act on it. There has to be a reasonable investigation and an inquiry. The director has to independently investigate. That does not mean that if you're a 5-person board, that you all have to go out and conduct 5 investigations. You are going to presumably have professional management that will follow your mandates, conduct the investigation, and bring back the materials that is the result of that investigation for the board to deliberate on. That's what I'm talking about, the independent investigation. I don't want you to be in a position where you say, well, we've always done it this way, so what does this information really mean? What it really means is you have to look at whether or not you've always done it that way has to be changed. And before you all gasp and say, how can we possibly do that and change midstream? You are granted the authority as a corporate board member to change the things that you know are wrong, even if they're the decisions of boards that you actually sat on. You draw a line in the sand and you say, from this day forward, usually give 30 days notice of the change, we're going to do it this way. And that's because you have a right to evolve. You have the right to fix things that are wrong. Because once you find out that it's wrong and you keep on doing it, then you are in far much more trouble than if you were to correct it on a going forward basis. If it's something significant like, oh my God, we've always been doing this maintenance wrong, it's really the association's responsibility, not the owner's, please, you want to make sure you call your association's legal counsel and figure out how that board resolution should be worded so that the association is in a protected position. We obviously want to make sure that we're in a defensible position if somebody comes after the association. And remember, while you're going through this process, because you are a volunteer, you have the right to rely on the advice of your experts. And those experts can be anywhere from legal counsel, your community manager, your general manager, your financial manager, your attorney. You want to rely on those advice of experts because you get to stand behind the shield. This is the shield. I want you here. I want you protected at all times behind that shield so you are in a defensible position. Sometimes when board members say, oh, we don't want to call the lawyer, oh my God, that's going to cost $200. Really, I've never found a board that wouldn't beg to fix a major problem for $200 or $500. I get it. You're responsible to your association and your members to not overspend on your budget, but I also get it that you have an obligation to protect that corporate entity. And you need to put yourself in a position that you're on the right side of that investigation. Next slide, Connor. So ethics and proper decorum. So there's issues of legality and there's implications, and then there's real stories. So as I said earlier, ethics is a question of doing what's right. And often it comes up when there's difficult circumstances and there's no right or wrong answer. And so we're going to ask the question, is it legal? What's permissible under the circumstances? What's fair? All the things that we discussed before, and what feels morally right. We know that there are limitations on how associations are supposed to invest the association funds. And we know that because boards have to meet their fiduciary duties when dealing with the association's finances. Years ago, I had an association and their documents did not prohibit the investment of funds in the stock market. And I received a call from the board president asking if they could do that. I was like, no, of course you can't do that. And they gave all the reasons why you couldn't do that and how that was a violation of ethical behavior. And 2 days later, I received a note from the board and they said, you know, you really need to change your opinion on that. And I said, did the law change? No. Well, if you don't, we're going to fire you. Okay, would you like me to resign to make it easier? That's what we did. A year later, the board president, literally a year later, called me and said, you were so wrong. We invested $1 million. They were way overfunded. And we made $1 million. Basically, he told me I was an idiot. And I said, I'd give you the same advice today, but I'm really happy you made money. Stop investing. 3 years later, so it's 4 years total, I received a call from this woman and she said, hi, I'm so-and-so, I'm the new board president. I was just reviewing our files and I saw that you wrote an opinion letter to a board and that you told the board of directors that they could not invest in the stock market. So I guess there was some sense of morality there because they left my opinion letter in the corporate records. I'm not quite sure I could raise to that level, but they did. She read it and she said, would you even consider working with us? And I said, well, of course I would. My rates have gone up and I'd need to know exactly what you've done. Long story short, they lost the original $1 million, they lost another $1 million, and they lost another $1.5 million on top of that. The board president, who was denied coverage, this is before D&O policies were always providing under reservation of rights, a duty to defend in the insurance policies, said, we're not covering you. There is no way you are acting within the authority of the board. And the association was able to make whole in part by his sale of his unit with the proceeds coming to the association. Yes, that's an exaggerated story, but it is 100% true and accurate. It is my best example of a violation of ethical and moral behavior. Next slide. Thank you, Connor. Sorry for digressing into that, but how do you meet your ethical obligations? You're trying to live your real life. If you're working, you're trying to work. This is your night job. How do you do all this and do your due diligence so that you're competent? So you're not just bound to be honest, you're bound to be diligent and careful. And again, you get to rely on the advice of experts. We have case law in California, the appellate level and the Supreme Court level that lets you make the wrong decision. as long as you did everything right to get there, which starts with that investigation that I was talking about, including relying on the information that is provided by the association's experts. There's one thing that I want to make sure that we're all clear on. You cannot excuse imprudence on the grounds of ignorance or inexperience. We have case law that goes back to 1965 for associations, Burt versus Irvine Company. So if you think that you can say, gosh, I just didn't know, the answer is not good enough. Sometimes not doing something can be a breach of a board member's ethical duties. I have a Sandraism, however. Making a decision not to do something is different than not doing something. It imputes that you evaluated it. It imputes that you investigated it. And ultimately, you made a decision as a board and a board member ethically that this was not in the best interest of the association to take action. That's an affirmative decision to not do something. That's something I want to see in the board minutes if I need to defend you in a civil action. And you've made the decision because you don't think it's in the best interest of the association. What that means is don't turn a blind eye at matters that are going to affect the association. By doing that, you fall way into the gray matter on that ethical and moral compass. And you could avoid that so easily by saying, here's what we did, here's why our decision was made, and here's our board vote that supports it. Be aware of the issues. Listen to your managers. They're not just jawboning you and trying to annoy you with all of the laws that are going on that are affecting associations at all time. Listen to what they're saying because they are the ones that are listening to the heartbeat of what's going on in our industry. I'm going to go over some things that you have to be aware of. These are all the areas of which you have an obligation to be mindful of. So one is a duty of knowledge. You're responsible for enforcing the association's governing documents. We had a Court of Appeal case a couple of years ago where the judge was saying to a board president, did you read the association's bylaws? She'd been the board president for 27 years. No, I never read them. And the judge said, well, had you read them, you'd have figured out how wrong you are. I don't want that to be any experience that you ever have. So what that means is the board is responsible for enforcing the governing documents. Read them, know what they are, be aware of their contents. So when something comes up, I can say to you, your CC&R say thus and such, and you'll know, oh, I'm going to look in the CC&Rs. I remember seeing that. And you have to review and evaluate the association's business records. Be mindful of the law. You are not required to know what the law is. Just like your community managers, you're required to recognize the red flags so that you know, I think that doesn't sound right based on such and such. You don't have to know the answer. You just have to be able to recognize the potential of that issue. So that's the duty of knowledge. The next is the duty of financial management. We know the Davis-Sterling Act and the California legislature takes that really seriously. Last year, they implemented a new law that requires you to look at and approve the financials monthly. And if you don't review them monthly, you have to have a committee of the board reviewing them, and then you affirm their approval at your next board meeting. That's because you're responsible for the financials. It's other people's money. So you have to understand that you have to make sure the association's funds are protected. That means you have to collect assessments. I recognize it's difficult when you know somebody is in a bad way, offer them a payment plan, but be consistent with everybody. If you've levied assessments that's your only income stream, please make sure that you have, under this duty of management, financial management, that you collect those assessments and that you know the financial condition of your association. Duty of maintenance, you don't win awards for keeping assessments low and kicking that can down the road. I don't want you to be in a position where somebody says you fell off the ethical obligation list because you knew you had to take care of things. It's your job to maintain, repair, and replace the common elements. If you don't do that, you are not doing your job. You have to be aware of the plan, and you have to be aware that we have a long game. You can't just look at the short term. You have to look at what this place is going to look like 10 years from now and 20 years from now. That's why the reserve study components are based on a 30-year plan for the viability of the association's common area components. I run into situations all the time where I'll hear a board member say, I'm not going to do that. I won't be here 4 years from now when we need a new roof. And I say, but we'll be thinking about you when that happens, and your liability for the decisions you make now, assuming that a statute doesn't run, will travel with you when you're no longer living here. Stay behind that shield. Do the right thing so that we can continue to offer the protections that you need. All of these things, by the way, go to morality and to that purpose that we're talking about. The next is the duty of operation. I know some of you don't have a managing agent. You think that your association can't afford it or that you can do it all, do it better. The board is responsible correctly for the operation and management of the common area components, but you get to delegate that to others, such as your management company or your general manager and your employees. And you get to pay other people to do it, so that you are making sure it's done without you having to be responsible to actually do that work. And there's the duty of enforcement. You're responsible for enforcing the association's governing documents. I have another Sandraism: use it or lose it. If you are not going to enforce the association's governing documents, amend them, get rid of it. One of the first causes of actions in every lawsuit against a homeowners association is failure to enforce the association's governing documents. If you're not enforcing it, get rid of it so that you are not liable for a particular use restriction or something that you're going to have to go after against a homeowner in your association for architectural restrictions. So make certain that we know what actions require disciplinary action, and make sure that you are consistent. Everybody who is a violator has to be treated the same way. Can you make exceptions on extenuating circumstances? Absolutely. That's when you want to speak with your manager and your association's lawyer about how your decision in that board resolution should be worded so that there's no negative liability on the association when you were trying to do a good thing. And I want to just have on this duty of enforcement, for those of you that don't know, although there's still things called neighbor to neighbor disputes, that's not something that we say glibly or throw to the side anymore. Oh, that's a neighbor to neighbor dispute. In 2016, the California Government Code changed, and it requires that associations provide a hostile-free living environment, just like employees are entitled to a hostile-free work environment. What happens when somebody is entitled to a hostile-free living environment? It normally, with an allegation, will trigger the nuisance provision in your governing documents, which means, guess what? Yes, under duty of enforcement, you have to investigate that and make a decision. If what I'm saying to you right now is Greek, please reach out to your association's legal counsel so that you can get on the right side of this issue. So, and then there's the duty of leadership. You're in charge. Make sure you're future-oriented, team player, self-discipline. You're an appropriate delegator. I'm sure you could do it all. You're just not supposed to, and you will not do it all well, and you may not do it all right. So make the decision to allow yourself to stand behind that shield, do what you need to do, and make sure that others are doing what you've delegated them to do. Connect all of that to your community and to your values. I'm perfectly happy with your being passionate about your association and its success, but there's a lot of hard work you have to do to meet your ethical obligations to get them there. So let's look at our next slide. Let's see here. I'm going to go, Pat, to our ethical obligations. So ethical obligations: due care, competence, diligence. let me just see here, let me make sure. So you're not bound to just be honest. You have to be diligent and you have to be careful. And, we talked about what those obligations are already. So I think, Connor, we're going to go to the next one, to maintain and protect associations from liability. So this is a California Corporations Code section. And this is really what helps us with our fiduciary duty. This keeps you from being liable as a volunteer. So it's my favorite thing. All you have to do is act in good faith in the best interest of the association and use such reasonable care as an ordinarily prudent person in the same or similar circumstance. You are going to be compared to other homeowners associations. So even though you have the same corporation, as you're bound by the same corporations code as large commercial public corporations, you have the layer of protection because you are a volunteer. That code section that I just referenced is called the business judgment rule. And the business judgment rule, when you comply with it, it gives you a presumption that your decisions are based on sound business judgment and that you are therefore making ethical decisions for your association. That presumption is there. It's rebuttable, but it's rebuttable by a really high standard. It has to be a factual showing of fraud, intentional bad faith, or overreaching, that you're not acting in the best interest of your association. When you do this, it allows us to say that you are acting ethically, and you get my gold star for doing that. You can't make decisions, as we discussed earlier, for self-interest. You can't make decisions that could adversely affect the association. You can't act in regard to a specific sect of the association or a group of homeowners. You have to be acting for everybody. Many times board members will run and will say, oh, I'm going to be the transparent board member. This is unbelievable that our board doesn't allow us to see their executive session minutes. They're cheating us, they're stealing from us, they're doing all of these things. And then they're elected to the board and we do board member training and I tell them about some of these things. I said, oh my God, we told everybody that we were going to disclose all of these issues. Well, but you can't. You can't do that and meet the business judgment rule. We want to make sure that you're meeting these fiduciary duties, and we want to make sure that you meet that standard of an ordinarily prudent person in the same or similar circumstance. So in the example I gave you a minute ago, where the judge actually asked on the stand the board member if she ever read the governing documents, and she said no, the court said, I don't even know who I would compare you to in trying to give you that protection that you are seeking. And the Court of Appeal did not give her that protection. The Supreme Court overturned it more likely than not for the sanctity of protecting volunteer board members, because of course they probably thought, who would ever serve on the board if they're not protected? Connor, I'll go to the next slide. So the association's interests, you have to remain objective, obviously, and you have to act as a board member. You have to actually put the association's interest above your own. You never take your board hat off. You are always a board member. That's why I say when you go on Nextdoor and you're doing the chatting thing on Nextdoor, you're doing it as a board member, even if you preface what you say by saying, I'm on this website or in this program or in this cloud as an individual, not as a board member. I have the most perfect example of a real life story. This was after the 2008-2009 financial crisis. We had an association that had 50% delinquency, 50% delinquency. It was horrible. Their common areas were literally locked shut with chain links, locked shut. And we had a board member that said, we have to go to foreclosure on all of our delinquent owners who are not asking for payment plans. And the board could not even engage in payment plans because they couldn't even pay for their water. They chose to let their landscaping die and keep their slopes watered, not because their slopes were better, but because they were worried about slope failure. Fast forward, the board went through the foreclosure process on a number of units. And as you all know, you don't know the name of the owner. You're not supposed to vote on them by name, but by track number. The board received a number of different requests for approval by the managing agent to foreclose, and the board met in executive session. And the board member said, this is before the statute that said that it is a violation to vote on your own matters, said, I need to leave the room while you vote on this. And everybody said, why? And he said, that's my unit. They said, we're not going to foreclose against you. And he said, the hell you're not. And they voted to foreclose on his unit. But the other 4 board members decided that they were going to do something and talk about how selfless this board member was. And the homeowners in that association, even though 50% of them were delinquent, brought that man's unit out of foreclosure. Okay, I recognize that guy is either insane or should be a saint, but it is my very best example of why you have to put the association's interest on over your own. That association fought hard to stay out of bankruptcy and they succeeded. Next slide, please. So what should you do? I think you should have a code of ethics, or at least a code of conduct, so people know what you're looking at to guide you, and the people who follow you are bound by the same document. Can you make somebody sign it if they refuse to sign it? Probably not under your bylaws, but what you can say is whether or not a board member signs it, this is the current code of conduct that is established and voted on by this board, and we will hold all board members to that standard. Before you make that decision, please speak with your association's legal counsel. Why do I suggest it? It defines your value system. It allows people to know what you're talking about when you talk about loyalty and fidelity and honesty and integrity and all of those things that are going into the decisions that you are making. And homeowners can know about your code of conduct. There's no reason that they shouldn't. It's good for them to see the standard that you are holding yourself to. If you remember earlier, I said you should be held accountable. You should, but I want you to have all the protections you're entitled to, and this is how you get there. Next slide. Importance of keeping records. Records will be your evidence to protect yourself and your association. Speak with your association legal counsel about how long you should be keeping records. Minutes are the only thing that are forever. You have to keep them forever. Some attorneys will tell you, well, contracts are, the statute of limitations is 4 years, get rid of your contracts then. I'm not all that a fan of that. I think that contracts show a history of an association, and it shows the backup for the reason behind why boards made decisions. But decide what you're going to do with records and how you're going to keep those records and for what period of time. You want to look at tax laws for how long you have to keep your financial records as well. Sometimes it pays to pay for storage of those materials instead of keeping, if you have a management company, the records with the management company, because sometimes from management company to management company, everybody's best intentions notwithstanding, records may not survive in the condition that we would like them to be. So it's just a consideration. In the next slide, we will talk about use of specialists. Those are the people that I was talking about, your experts. Demonstrating integrity. This is so that you're meeting your ethical obligations. Why did we pick this company, this person? And again, you're going to focus on those long-term results so that everybody knows you are in the long game. The business judgment rule that gives you all the protections, it requires you to act in good faith. And by giving you the right to rely on the advice of experts, why, other than you don't want to spend the money, would you not exercise that right so you have all of those protections? I want to tell you very briefly about a case. It's called Athen versus Portofino Cove. And that board for 9 years put a Band-Aid on a problem that happened every single year. Every single year, a homeowner had backup of wastewater in their unit. And every year the board came in, they snaked the line for the sewer backups. They fixed the unit and all was good, and the unit owner fixed their unit. That went on for 9 times. After the 9 times, the Athens sued the association and said, "Are you kidding me? Thanks for fixing my unit, but we've been ankle deep in poop 9 times, and all you did was do a Band-Aid fix." And they were spending good money after bad money, but they weren't solving the problem in the long term. That board didn't do so well in that litigation. Look at the big picture so everybody who comes behind you knows what you made the decision on. So let's briefly look in our next slide, Connor, at the board duties. So volunteer community association board members have the same duties as the board members, as I mentioned, for public corporations, so McDonald's, Intel, Texaco, Apple, doesn't matter, name one that works for you. But you are not compared against them. You are compared against other board members who are similarly situated. So first we start with your socioeconomic group, then we look at other associations in your geographical area. So we really get in litigation a good mix of who we are going to compare you to. So you should be focusing when you're making these ethical decisions on things to make sure you're going to be on the good side of that analysis. You have to protect and preserve the common area. We already know that. It's real property, it's personal property of the association, and it's your intangible assets. You have to manage the association's finances. You have to meet the statutory budgetary obligations. You have to do the audits. You have to do the annual disclosures. By the way, on annual disclosures, we have an annual disclosure checklist. If you don't know what that is, give me a call or email me, even better yet, and we'll send you a free copy of this. I discussed it with Dave and Connor before to make sure that wasn't improper. They said it wasn't, and they are so kind that they are also going to put it in their, I think they called it their store. It's for free, but so that you can go on ECHO's website and also pull down the disclosure obligations. For those of you that are professionally managed, you probably have access to that through your association's managing agent as well. I'm going to discuss a couple of the things that really constitute your legal requirements and what is binding for you. So let's see what that looks like in your relationships, and we'll go to our next slide to do that. So your vendors, management, your homeowners, your relationships with the other board members and your association. You have interactions with each of these groups of people. And you have your professional relationship, and we want to make sure that's at the highest level. So there may be nothing wrong with you using the association's landscaper. But when your homeowners are unhappy with the landscaping condition, and they see the association's landscaper in your front yard, their assumption, it's the appearance here, is that that landscaper is working at your property because you're a board member, doing that on the association's dime instead of doing the landscaping that they were hired to do. That is a no-win situation. There are enough vendors in the world that you don't need to take on that exposure to anger, not necessarily to liability, because I believe you're paying the appropriate fair market wage to that vendor for that service, but it's how it appears to third parties. Keep things separate. There are enough good vendors out there. Please don't expose yourself to liability. This applies to all of the relationships. I'm calling that one out in particular because it seems to be a place that people trip over all the time when they're on the board. Let's look at the next slide. These are your legal obligations. Have a working knowledge of your association governing documents. I've now said that 3 times. It wasn't because I forgot, but I said it twice before. It's because it's always shocking to me when people don't. Please look at your governing documents. I know when you're a new board member, it can be intimidating to join a board where everybody else is familiar with it. And when people are saying to you, that's the way we do it. It's the way we do it. It's always this way. That's the right way. How about if you review those documents yourself and you decide for yourself on behalf of the association as its board member, what those documents say, and if it's the right way for you. If it's legal counsel, please, if it's a legal issue, hire legal counsel. Use your counsel on the front end of an issue. Preventative lawyering is the best and least expensive lawyering that you will ever have. It does not feel like it when you have to spend $1,000 to review a contract, but that $100,000 contract can cause you so much liability. Why would you not want to make sure that not just you, but your other board members and your homeowners and the association are protected? When you go through those documents and when you get that legal advice, then make your decision, because then you will make an ethical decision. Even if you're wrong, you did everything right to get there. Next slide, financial reports. So you have an obligation to maintain current and actual financial records. And yes, that is a delegable task, but you as the board have to review those financials monthly. So you have to make sure that you understand how to read your financial statements. If you don't, your managing agent will be more than happy to help you. Your financial advisor will be more than happy to help you, just like you contact your lawyer or your insurance broker. The Davis-Sterling Act has very specific requirements for financial records. I mentioned that to you before. You have to look at them monthly. This is a whole topic unto itself. I literally could spend 4 hours on it. I'm not going to, but also this is included in that disclosure checklist that I talked about a few minutes ago. You'll look at that and you'll see, oh, here are the things that I must do. When you're looking, I'm just only going to discuss a few of them. When you're looking at the financial documents, you have to look at the current reconciliation of the association's operating accounts, the reserve accounts, and you have to look at actual versus what's budgeted, because you have to be responsible for the differential. Sometimes you're under and sometimes you're over. Look at that income and expense statement so you really can see what the true picture is for the operating account and for the reserve account. It's not one of those things that you can just say, oh, let management do their job. It is your job to make sure that you understand the financials, because it's your decision that can expose the association to liability. And you have to be responsible to have control over those financials. I am not a fan of micromanaging management, and that is not what I'm saying here. You each have your own role in making sure those financials are correct for the association. So what do we do with the funds? Let's look at the next slide. We have to expend funds to achieve the greatest benefit for the association. There's case law on that. It says use it correctly so that we can use it in the best way possible. Association reserves are established for a purpose. There are line items, and although it is true, those line items are recommendations, the reality is that we'd like to follow those recommendations to the extent possible. Deposit the funds in FDIC insured institutions. Make sure if you're cash flush in any particular moment in time, that you move your money around as necessary so that you don't have any more than $250,000 at any time in any one account, because you want to make sure you have the protections of that federally insured institution. And don't commingle your reserve and operating funds. There are times you may have to take money out of reserves to cover an operating expense, like in the insurance premiums. You're going to do that by a loan. You'll work with management and association legal counsel about how to do that. That won't constitute a commingling of those funds. There's a reason we have the operating account and the reserve account. And it's your ethical obligation to make sure that those accounts actually stay separate. Using those funds unwisely or for an improper purpose can lead you to the ethical violation. Think about my poor association that invested in the stock market. We'll look at our next slide. We'll talk a little bit more on complying with fiscal responsibilities. So you have to look at the Davis-Sterling Act on this as to what your obligations are, and California law. And of course, you're a corporate entity. If you're not a corporate entity, you are treated as a corporate entity under the Davis-Sterling Act. It means you may not be paying corporate taxes, but that's the only thing that you're going to get out of. I like for everybody to be incorporated for two reasons. liability. It gives you a little bit distance from having the corporation, the it. And also, if there's a catastrophic loss, you can't get any government loans like an SBA loan for your association if you're not incorporated. So think about that and make a decision to speak with your legal counsel if you're not incorporated to see whether this is the time to do it. Retain a CPA is required for accounting and tax advice. If one of your board members is an accountant, that's fantastic. Don't have them do your tax work. You need to have your board act as the board, and you need to have your experts act as your experts. This is a corporate entity. It is a business. It is a corporation. You have to act like one. Budget, file, taxes, comply with the law, and have your experts actually help you do that. On reserve investments, again, this could be an entire day's program, but the most important is the first bullet point. Safety first, liquidity and yield. Safety, liquidity, yield, and then other considerations. You'll always remember this if you didn't know it before, because you will remember that you can't invest in the stock market and have safety be your first investment. Be responsible, as I said, for the future and making sure that you understand. I know you want to keep assessments low, but that's not how you get your gold star. How you get your gold star is by maintaining your property and making sure you don't expose it to liability. And insurance, let's look at our next slide as we're on the home stretch here. Seek professional advice for insurance coverage. You had one of today's vendors present to you, and he talked about his learning curve going up once he began working with homeowners associations. And I know of his work, and his learning curve is really in a good place. Your insurance agent for your personal lines, they don't know what a homeowners association is. They don't understand what your obligation is as a board member to the corporate entity. If you have an insurance broker on your board, one, remember my words about a conflict of interest. They don't need the association's business. They don't, and they should not have it. If there is a mistake that is made and they have to stand up in court to stand behind that shield, it's going to be a bad day for them and a bad day for me to try and protect them in that mode. Remember, directors and officers have frequently been held liable for negligent nonfeasance, where you knew that something was wrong and you didn't do anything about it. Please make sure, even with your insurance coverages, that you make sure that you have the right amounts of coverage so that you are both morally and ethically meeting your obligations. You should note that you get all these coverages, and when I'm putting you behind that shield that I want you to stay behind, remember there is one thing in the statute, and this is the Civil Code 5800. It doesn't protect directors from liability for omissions that were willful, wanton, or grossly negligent. Willful, wanton, or grossly negligent. You can't be any of those things and be meeting your ethical behaviors. So I'm pretty sure that will not apply to you. Next slide. Communications, maintain records of your membership, make annual disclosures, and comply with homeowner requests under the time frame required under the statute. It's the right thing to communicate as required by law, but it's not just the right thing, it's required by law. So when you get a demand for records, if it's an association record, please make sure you respond within the right time. And we're going to look at the last couple of slides. Maintenance is the next one. Hire licensed contractors and hire insured contractors. Make sure the people you bring on your property are not exposing you to liability, but are protecting you, because you will be held responsible for accountability. For those of you that don't know, if you bring anyone on and you're contracting for work that exceeds $500 or more for materials and labor, you have to have a current valid license by the Contractor State License Board to be able to do that for the association. So please make sure you do, and make sure the insurances are in place. If your vendor, your contractor doesn't have insurance, the law will hold their employees, if they're hurt, to be your employees, And if you don't maintain, which you should, workers' compensation insurance, you will be held liable and responsible for their damages. So let me say it again, hire licensed contractors and hire insured contractors. It is your obligation to make that prudent decision. Next slide, I'm going to wrap it all up. Your ethical dilemmas. Look at the conflicts of interest. We talk about that. Don't be abusive. Don't be intimidating, but don't give in to people who are trying to intimidate the board. Stand firm when you need to, because you know that you did all the preparatory work to be able to be in a position to protect the association. Don't lie. Somebody is going to find out you lied to the board or you lied to the members. You have a duty to disclose, even when it's a disclosure that may harm you. The obvious misappropriation, embezzlement, statutory defenses may not apply if you do that. But remember the questions every time you are faced with an ethical dilemma. Is it legal? Is it balanced? And is it right? Let's take those questions you were talking about, Dave.
Okay, we got a whole bunch of questions. So we're going to take a couple seconds here. I'm going to ask everyone to go to the Q&A feature. If you put a question in the chat, I tried getting you to put it over into the Q&A side. But go to the Q&A feature and vote for your favorite questions. We have one that has 21 votes on it, so I'm going to start with that one. I'm uncomfortable with the fact that several board members conduct board business discussions, debates, and expressing decisions on board issues via email. It is my understanding that only administrative matters can be done via email. Scheduling meetings, sending out, scheduling meetings, sending out draft minutes to approve the next door open board meetings. How best to remind them to hold discussions and debate until we have an open board meeting?
Well, that's an excellent question. So you could remind them by saying, it's illegal to do what you're doing. The Davis-Sterling Act prohibits you from conducting business of the board via email. There are exceptions if something is an emergency or an urgent matter that places the association in harm. But you have to do two things if you're going to do that, and it requires 2 votes via email. The first vote is the agreement to have that vote, so you can say what the topic is going to be and conduct that via email. And that has to be done by unanimous decision of the board. And then the second is the vote on the issue that is so urgent. So an example would be everybody, including your broker, your agent, your board, your manager, thought our insurance was expiring next week because we received an incorrect notice with an incorrect date, and it's actually expiring at midnight tonight. And if we don't renew, the difference in price will be $21,000. Get on that email and conduct that business following the criteria I just said. Otherwise, stay away from email.
Got it. That's very good advice. Okay, what responsibility does the board of directors have over vendors like landscape companies to make sure that they are doing a good job, i.e. checking the workers, et cetera, enforcing the written contract? So it's the oversight process of the landscaper. What responsibility does that fall under an ethical concern, or is that just the role and responsibility of the board?
So there's actually an ethical component to it. First of all, you shouldn't be going to speak to your landscapers employees, especially when you're telling them this is wrong, this was supposed to be this plant here, and this is a tomato here, and this is supposed to be an olive tree over there. And you should be speaking to their employer who likely told them where to plant those things. And if it's wrong, have that conversation with your vendor. Remember when I said a few minutes ago about in 2016, we had a change in the government code where homeowners are entitled to a hostile living environment. We had another change as well. And that is not just are your employees supposed to have a hostile free work environment, your vendors' employees are supposed to have a hostile free work work environment as well. So you're ethically breaching your responsibilities if you start going over to that vendor, let's say the landscaper's employees, and haranguing them about what you think is wrong and how you don't like their employer and you don't like the landscaper. And is that my tree in your truck? Are you taking my tree? Are you stealing it? These are all real life things that I deal with all the time where people lose control, and that's in that supervision. The ethical part is making sure you don't infringe on those rights. So yes, you have a right to do that. Go and look, but keep your mouth quiet and bring your concerns to their employer, to the actual vendor, not the person who is performing in that moment. There's one exception and one exception only, and that's a health and safety standard. You know that somebody electrically is doing something incorrectly, or there's an issue with the elevator, all bets are off. You say, stop, don't move. This needs to be addressed in this moment. And that really is my only exception to that rule, because there's so many landmines when you do what was asked in the question.
So the board is theoretically has the responsibility to make sure the contract is executed properly and basically to stay out of the way. And would you recommend that they have a contact person, a lead person on the board, or is it the whole board that they're reporting to? How would you do that?
So that's an excellent question too. I don't want your vendors to be hearing from 5, 7, 9, or 11 boards. My biggest is 11, so I use those numbers. If you have a manager that is responsible for compliance with your vendors, get that information to the manager. If a representative on the board, such as the board president, wants to be that liaison, as long as you all know that the board president is the contact person who's going to go to the landscaper. I'm just picking on landscapers because it's easy in this context to convey the board's concerns and or issues. Let them go, but that requires an absolute amount of trust between the board members that the view of the whole board is going to be properly conveyed.
So this is an interesting question, and we see this all the time, is that a member of the community is a contractor and he would like to, then he knows that they're going to be putting new roofs on or whatever, painting. And so he wants to apply, or she wants to apply to the board for the work. Can you take it from the perspective as somebody who's not on the board versus somebody who is on the board? And what do you do? How do you work through that? I've got a couple questions about that.
Okay, so I think I addressed the board member doing it. So if it's a board member and you insist on going through this process board, then you're going to have what's called sealed bids. The bids do not come to the board, so there's no chance that that board member is going to see everybody else's bids. Let's say they go to the managing agent and ththey're sealed, and those sealed envelopes are opened in front of everybody so that everybody knows the board member who is competing for that business didn't have a heads up by anybody. That's one way to do it. Please don't do it, but it happens. The next is the homeowner living in a community, and we see that frequently, and happens to be frequently with landscapers. So it's funny that we're using that example. I have a problem with it, and the reason that I have a problem with it is you wind up crossing over. Let's say that person's doing the job, but they're a horrible homeowner. And all of a sudden you're being critical of them on their work side, on the contract side, and they say that has nothing to do with my work. You're saying my work is bad because I'm 4 months delinquent in assessments. And I have had that happen before, and an association gets caught in a quagmire. And I had an association that stopped paying under the contract because the homeowner was not paying their assessments. And there's no right of that offset. And of course, even though the association was being harmed by that not paying homeowner, the homeowner, contractor in that case, sued the association and they prevailed. They had insurance defense counsel who did a good job. But the association really got stung, and they got stung badly in that situation.
So here's one with a contractor. Happens to be an accounting firm that's handling the accounting of the association, and the treasurer is responsible for reading through the monthly reports and looking at all the particular payables. But they then go to the full board for review, and the president finds that, hey, there's some things in here that just don't seem right, and she picks up the phone and calls the CPA or the accounting firm and starts questioning them about the decisions that were made. And this is about roles and responsibilities. Can they do that, or should they do that, or how should they deal with it?
Well, yes, they can, but how they do it should not be the manner in which you explained. It should be by the board of directors designating somebody with specific information. If you have questions about the output of that vendor, you have a right and an obligation in meeting your moral compass to find out what is really the correct information. Or did you actually get the right information upon which you're making your decision? But you don't want one person going to that vendor, even an accountant, even the attorney, and attacking it without everybody knowing and agreeing that it is an issue. Because go ahead.
So work through the board. I mean, basically, you've assigned one person, a treasurer, to deal with it. But let's talk about it at the board level or directly with the person that has that relationship or that was delegated responsibility. That makes
Correct.
sense.
Correct.
Okay. So here's another good one. Meg asked, is it legal, ethical for a sitting board member not up for re-election to actively campaign against someone who is running for the board or up for re-election? I get this regularly, this question. So
they're currently still on the board?
Yes.
No, they don't get to do that because you can't do that if you're a current board member. You can't campaign. And I know you're not campaigning for yourself, but you're campaigning on the opposite side against somebody else. It exposes the association to the potential for harm and liability. Not a good position to be in. I'm going to say no, no, and more no.
Yeah, and ethically, it's probably not a really smart thing to do either. So yeah, that makes really good sense. Thank you for that. My association has never, and this is from anonymous. There's a lot of anonymouses here. My HOA never has executive meetings. They discuss all the matters, including owner discipline, in open meetings, and have no clue what confidentiality means. Can board members talk amongst themselves to make the decisions and get other neighbors' input outside of the executive committee and act on it? Our management company is either clueless, and I won't go into that, but she never guides the board. So I guess we got a problem with how decisions are made in sort of the hearings process and have an executive committee. So maybe you can address why we have the executive sessions and kind of what's going on there.
Okay, so there's about 27 questions in that one question.
Yeah, there's a lot.
There's a lot. So I'm going to say something that I will venture to say the majority of the people on this Zoom don't know. And that is the statute actually says that disciplinary actions have to happen in general session unless the owner asks to go into executive session. But all of the lawyers in our industry, we just lie about it. And we say that everything has to be done in executive session. Why? Because if a homeowner stands on ceremony and insists it be done in open session, we will do it that way, but you can be certain that I'm going to be there. Because it's a moment in time when the association is going to be exposed to potential liability for claims of defamation and violation of the right of privacy. This is a terrible provision of how it's drafted in the statute. All of these matters should be handled in executive session under the confidentiality of executive session so that the homeowner who's being accused is protected. Even if they did the thing that's wrong, you have all kinds of policies and procedures in place about what you're going to do with their actions and their behavior, but they're still entitled to that hearing. They're still entitled to that opportunity to be heard. And after that opportunity to be heard is over and that hearing is over, the board deliberates and makes a decision. That happens in executive session. If you're not getting that guidance from your other board members or from your association's managing agent, demand it. Say, we need guidance on these procedural issues that can expose the association to liability. What are they? And ask that question.
Yeah, that's very good advice. That's spoken very well. Here's a question. How can we persuade the board of directors, and I presume these are homeowners, persuade the board of directors to accept a homeowner proposed ethics policy to be written into the CC&Rs? they have responded, it looks like a solution in search of a problem. So this is a pretty straightforward question. You know, the community is saying we have some issues. Can we put something in place? What's your recommendation there?
So it doesn't belong in the CCNRs. I don't think it even belongs in the bylaws. I believe it belongs in a standalone policy that we had talked about earlier, being very clear on what the ethical policies and procedures are. And it's not just for this board, it's for the next one and the one after that and the one after that. It sets the floor of conduct that will be acceptable, and anything below that floor will not be acceptable. And we will look for liability if it's not. So I appreciate that the homeowners are asking for that. And I'm fine with their asking the board to develop a policy that they want this and future boards to be governed by. I just don't believe that it belongs in the CCNRs.
Okay. So if a board, if they request it and they're getting nowhere, which is obviously the case, then the solution is, you know, maybe run for the board. I mean, that's kind of
run for the board. You know, there's only one group of people that can drive the bus at any particular time, and that's the current board members. And when I say that, homeowners are like, that's unbelievable. You're giving all the power to the board. And it's like, yeah, they're the group that has to make all the hard decisions here and do all the heavy lifting. But no, I'm not giving them all that authority. The authority is actually held by the homeowners. If you don't like it, don't vote me in again. If you don't like it so much, recall the board of directors. Otherwise, give us your constructive criticism. We will try and do the best we can with it, and we'll move forward. And run for the board. Don't be on the sidelines complaining. Run for the board. Be part of the solution.
okay. And so here's just a quick question. I think it may not be ethics oriented, but we have 9 votes on it, so it's pretty high vote. So minutes are generic, not really telling any future director what really happened. What governs what should be said in the minutes?
So I take a play on words with minutes. I like to call them minutes. And minutes are supposed to be action items. Remember, they are discoverable in litigation, both general and executive session minutes. So when it comes to minutes, actually, less is more. And we don't do he said, she said. It is the action items of the board. So a little bit of a leeway up to the motion and the vote and the decision.
Great. Okay. How do you handle an owner who demands transparency on everything, but when becoming a board member is not prepared to communicate anything much at all?
Yeah, that's when I say, didn't I write you a letter about that when you were a homeowner? It happens. Sometimes it happens, and I mentioned this briefly at the beginning of my talk, that people will run on the transparency platform, and then when they get on the board and they see how much work it is and how much confidentiality is necessary, that they're like a deer in the headlights. And it takes a while for them to figure out, can I say this? And can I say that? Here's really what I need to make sure that we all take away from this. I'm bringing it back to the ethics and the moral benchmark. And that is, you shouldn't be talking as a board member outside of a board meeting. Stop talking to people in the hallway and on the streets and in the clubhouse about association business. You will wind up inadvertently binding the association to something that you never had the intention of binding them to. We have a case in California, a Court of Appeal case in Southern California in Orange County, where a board president, when asked by a homeowner, do you like this color paint? And the board president said, that's really beautiful. It was chartreuse, and they were doing samples on the side of their house. And shortly after that period of time, when the board president said, that's beautiful, the entire house was painted chartreuse in a community where a board is so amazingly great about enforcing their architectural guidelines and standards that they invest in coming up with new paint palettes every 3 years. And everybody complies except for the chartreuse house that's been there for 20 years. So don't be talking about it on the street. Be talking about it at a board meeting.
Okay, so I think I think we've talked enough. We have several questions about what can a board member talk about outside of the meeting, and you're saying don't, right? I mean, basically don't. Okay. So I think we answered that one, Lori. Okay, here's one. Our CC&Rs mandate a 3-person board, but there is also one question of simply, well, I'm having a hard time reading this one. Let me move on to another question real quick. What about a homeowner that is submitting his proposal to become a vendor? Should it be handled like, how should it be handled? I think you answered that. Okay. Okay. When are board resolutions required?
So board resolutions are required even in your minutes. So the reason that I like board resolutions is it shows what the board relied on when it made a decision. And it can be as simple as the board of directors considered a request to repipe the south side of the such and such. And as a result of repiping the south end of the such and such, the board of directors is considering a special assessment. The board is outsourcing the investigation for the costs and has voted that Joe and Mary can be the representatives of the board to continue the conversation and bring back information to the board. It's a long resolution, but it covers so many things. Board authority, why you're dealing with it. It lets homeowners know a special assessment is likely coming and that there's a component failure. You do all of that in those 3 sentences. And the corporation is protected, the board has acted ethically, and you're certainly meeting your duties as a representative of the association.
Okay, so here's an interesting question. There's a board member, current board member, that knows that there's another board member that's been on the board for a very long time. He's an older, or he or she is an older board director, and they've been doing things that are, according to this, inappropriate. For example, using the plumber, the association plumber, to fix their plumbing, to do whatever. And so she's asking, okay, I'm on the board now. I see this. It's obviously a problem, according to her. What do you do about it? I mean, do you ring the bell? How do you address it?
So, and I did address that earlier in my talk. You ring the bell. You ring the bell before all of the board members, including the violating board member. Hey, Joe, I know that you've been doing this. I'm just assuming that you don't know that the appearance of that is really wrong. It makes the association look bad, even if you're properly paying for this. And we really want the board to be on board with a unified position that we're not going to use the vendors. You can't tell me what to do. I'm going to do that. You then turn to your other board members and you say, could be an exposure to liability. What do you all want to do about it? Because what I want to do about it is to say this must stop.
Okay. Okay, so Karen Harris asks, what's the liability or the acceptability of an HOA president and the manager unilaterally making financial expenditures under an emergency?
Well, if something's an emergency, so it's imminent threat to health and safety and imminent threat to the property, you have to have a grown-up in the room. I'd like you to have some policy in place that entitles the board president or the manager and another board member, if the board president is not available, to make an emergency decision. I remember, it's a long time ago now, it doesn't matter, but it was Christmas Eve, it was pouring rain, and we had a hillside that was coming down, and the manager only had I think they had a $10,000 spending limit, and the contractors wouldn't come out without a $90,000 guarantee. And the board president and the manager got them out there, and it was more than $90,000. I mean, the whole slope had to be shored up, and there's imminent threat to homeowner homes. And you have to have a procedure in place to deal with that. And if they're fake emergencies, and that's really what the question is, then obviously you need to put a cap on things. But if they're real emergencies, let's assume that they are, but have a policy and procedure in place. So the manager is obligated to try and reach all of the board members. They can't reach all the board members. There's only 2 that can be reached. Get both of them involved with the manager and the contractor when that emergency decision is made for an emergency purpose.
Okay, so we're going to just take a few more questions here. I'm going to pop down to Daniela Franchini's question, which I think is interesting. Does a management company, as an agent of the board, have a duty to disclose a patent or latent conflict of interest regarding a proposed vendor?
I believe so, yes.
Okay, the manager does. So if you know about it, you have to do it. What about a board member?
Yes, yes.
Definitely with the board member, right? Okay.
Yes.
Okay, here's another one. Is it ethical, moral, or legal to levy a charge of over $500 or more to homeowners to pay for electrical vehicles? So this is the situation. There's a group of board members who are progressive and are interested in having a recharging station. They kind of go along with that, but others in the community can't afford it. They don't want it, but they're still kind of ramrodding it through the system. Is that, can you explain, is that an ethical decision, or is that something that needs to go to the community? What do you do about that?
I don't think that it's an ethical decision. Remember, any homeowner can make a request to install their own vehicle charging station. And if their exclusive use common area doesn't support a place for it, that they can make that request for it to be installed in common area at their expense. So we can really get around that question. I'm not sure it's an ethical question if the board makes a decision that this is not something that the community wants to explore right now for the association to install electrical vehicle charging stations. It's likely I would need more information to give a really good answer to that, because I don't feel like I'm giving a good answer.
Yeah, I mean, I've seen this happen where the board decides they want to push forward an agenda. They know the community doesn't support them, but they can, and so they do. And that's the big dilemma here. I think that's a question for the next reelection, maybe.
It's definitely a question for the next reelection. You did, but the way you just summarized that, though, I think you do bring in the ethical issue, because you're trying to make on that morality compass the decision for the common good and for the long game, not just the short game. So unless you're living in Iraq, the long game is we're going to have more electrical vehicles as time goes on. And maybe it is appropriate then for the homeowners to force the issue with the board, saying, can you at least investigate this? Hey, how about a committee? I'll be in charge of the committee, complaining homeowner says. And maybe you let them do that. And it's possible that they may bring something viable back to the board. In creating that committee, make sure they understand they're an advisory committee. They cannot bind the association, bring materials back, and ultimately the board will decide.
Okay, so here's the last question. We'll take this as our last question from Vicky, and she has a situation where a homeowner has come to her as a board member and said that somebody in the community, has violated the CC&Rs. And she wants to know if the board member has an obligation to bring that to the other board members, or to bring it to the manager of the property to deal with a violation of the CC&R.
So, as I said earlier, I have a Sandraism: use it or lose it. If it is a violation, you have to do something with it. Otherwise, if you're involved in litigation and the judge asks the question, does your association enforce its governing documents? If you're not able to say yes, that we do that and we do it consistently and uniformly, you're going to be on the losing side of that litigation. So if you know about it, you have to do something with it, bring it back to the remaining board members. If the manager knows about it, and this is a hard one because everybody wants to blame the manager, the managing agent for the association. You have to bring it to the board. So-and-so is doing such and such.
Okay, so I can see that we have 53 open questions. We've had over 100 questions total. And so we had a lot of interest in this and a lot of questions. And I really appreciate everybody's engagement. It's been fantastic, and especially Sandra. We're ready to move on, and so I just have some concluding remarks. So thank you so much, Sandra. I want you to know how much we appreciate you all the time, and especially for this event.
Thank you.
Okay, thank you. Thank you for being a member. But if you are not a member, ECHO holds more than 30 online educational programs per year and offers a vast array of resources for boards and HOA members. If you are not an ECHO member, please consider joining and supporting the oldest statewide association advocating for better communities and well-informed HOA boards and homeowners. To do so, simply visit our website at www.echo-ca.org and click the membership tab. Also, the ECHO Regional Resource Panel committees will resume their meetings shortly. You may remember that these in-person meetings were furloughed in 2020 due to the pandemic. We hope to have them back before the end of the year. I have some exciting news about a new member opportunity. Due to demand, ECHO is forming a coastal resource panel. This panel will address issues regarding global warming, sea rise, and the California Coastal Commission policies. Because it will meet virtually, we hope to have representation from all reaches of the California coastline. If interested, please contact ECHO directly. You must be a member to be admitted to the panel. And wait, there's a little more. We are organizing a new monthly board forum for ECHO HOA board members. Stay tuned for this one. It's a terrific way to connect and learn from other board members. It will only have board members on the panels and in the group. So with that said, I'm going to introduce Connor again. So Connor, you can come back in. Thank you everyone for coming, and we really appreciate you being here. Take care now.